have as long as it came from the own plants. You couldn't. But all right, so, and I was just responding to the sadistic interpretations of how these things could play out, and
no doubt they'll be tried.
But also you can see the discrepancies, as Robin. There'll probably be some disparities within the communities in terms of how they're prosecuted. For example, we had a case in Washtenaw County, of all places, where they're going after caregivers, of all places, where there's been open dispensaries in and around the area for a long time. I still don't understand how they can have the audacity to, under those facts and circumstances, just in the reality of time. And today it's even more hypocritical that these places stayed open, right? You've got a caregiver, I'm saying facilities in Ann Arbor, Ypsilanti, you might know of one or two. There was, remained open and they were protected, and I don't think there was any specific raids that took place, and maybe law enforcement didn't know that they were there, maybe, or maybe they turned an eye for whatever reason. But
they licensed some, and they recognized and tolerated some awaiting state direction.
For 6 or 7 or 8 years.
Yeah.
I got it. That's fine. And I'm fine. But we know that some of that was treated in the most vicious and violent ways in other communities. The point I'm trying to make is that I was in court with a caregiver, okay? And they're railing on his, the allegations being that his behavior was making money by interacting with dispensaries. He's taking this overage, blah, blah, blah. Well, I think it's, today especially, it's hypocritical when, since the emergency rules happened, that's the method by which it's been accepted to do that, right?
I would absolutely agree.
Okay, and the idea that the caregiver somehow, which is a behavior that is lawful, right, is somehow being penalized more so or considered somehow more culpable in this, gray area, to me is, like a fucking moral judgment that is not something that that should be made, right? Dispensary, okay, police, prosecutor, we don't care. It's a caregiver that brings it there, we don't care, like, which one's worse, who's the more, that is not a decision anyone should be making. And certainly you could back it up and say, well, the caregiver in that instance is clearly has a more identified stake. But putting that aside, my point that I wanted to make was, in this Washtenaw County prosecution, very vocal, outspoken, characterish kind of assistant prosecutor for the state. And, I know he's getting, updates from Pam. He's on that thing. He shows up at some of
the Prosecutors Association
of Michigan, and, he shows up at some of the marijuana law sections because it's open to lawyers of all, profession side of the
persuasions.
And, he's giving me his 2 cents on all the areas that I think there's going to be a lot of interdiction and a lot of police activity. You get the kids, and you got, someone can be driving around with 2.5 ounces. They arrest people for delivery for that shit all the time, So this guy's like, well, you got allowed to carry 2.5 ounces of marijuana. The people are going to be walking around selling it because that's what I've always prosecuted as felonious behavior. So the problem you're going to have is they're going to be doing it, even though they're allowed to do it, and it looks like crime before it happens. And I've always known it to be, despite the fact that the voters said that they're allowed to have that much, they're going to be selling it illegally. And that's what we got to stop. There's too much incentives, too much marijuana, 12 plants, low taxes, blah, 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 blah. Jamie, I'm saying all this for you because you would like to believe that, it's like fucking give up, give up. There's enough. Who cares?
There's so little incentive for them. I don't see that happening. Even if someone is selling, the worst that literally can happen to them for a first-time offense is a misdemeanor with no jail time. That's the worst.
One of the
but who would want to be on the fucking stuck to the court when it's legal and have to go through that grind? That's no longer that should no longer be an option. You know what I'm saying?
It
there should not be a judicial.
So with Dana, we might be able to change the complexion of that. We can't realize yet. It's hard to fathom.
I know
that there could be a change in tone of how this gets.
Well, listen, there's going to be. There's county sheriffs that act. Listen, I'm not. I'm just like I see some of the battles.
Opposition is going to stay alive and well wherever it can spout off. It
right. Will. The Michigan State Police are under the tutelage of her, but there's other
we'll have bad
local
rulings.
County sheriffs that do what they fucking want to do, and they're their own. elected official in that county, and there's we could have some standoffs. I mean, I think that herein lies the leadership challenge to Dana. Just to go about this. Like here, for example. Good point to bring this up. MSP statement on passage of Proposal 1. There's been a couple communities that have spoken out. This is what we're doing.
Have you come up with a final statement about the stacking scenario from your perspective?
I believe that the language in the Act unequivocally protects an adult growing 12 plants, and that behavior does not interfere with their activity as a medical marijuana patient or caregiver. So I would say combining them at the same location would be something that I don't see this law creating an identifiable crime.
Not legal advice.
Not legal advice.
We know that's going to get challenged,
Right.
and we know that the decision's not going to turn out well in some places.
Listen, I read, and just as an example, the enclosed lock facility language that cannot be except for a patient or is other than a registered caregiver or patient, where they clearly say two people could be in there. Not the registered caregiver or patient, meaning two people, any caregiver, and then they came out with that shit and balls. So I'm telling you, I could tell you what the law says. The sadism of the Court of Appeals,
exactly
whatever
correct,
is the thing we're talking about. But I do agree that the writers of this went out of their way to give the intention of this act to not let those two things interfere with one another.
And further direction to the courts too when they're talking about if somebody's habitual or not, or how you really treat these things, or
For
that
sure.
kind of stuff.
Michael, what you said just is not true, though. What you just said is they went out of their way to indicate that those two things are supposed to work together, but they didn't. Because if they did, all they would have said was it works along with it. They would have said in addition to.
No,
There's
he said
phrases
they would operate opposite each other, but
opposite each other.
Well,
No.
at the same time.
I'm saying the oppositions. If the interpretation of the law that would be negative, I'm just looking at the most sadistic.
He's saying that one shouldn't affect the other.
Well, I'm saying the law says that.
It says that. That's what I'm saying.
Right.
So they're going to
with that
operate
being-
in tandem.
Right.
And
With
that was the
being
intent.
said-
too.
right.
It says it, and that is the
That's
intent.
the
But what I'm
intent.
saying is,
But
I
the
can
courts
read.
are not going to respect that everywhere.
Yeah, they'll give you some intent.
I'm saying that that there will be an interpretation at some point in time, and as we're interpreting this in the most sadistic way of what could happen, listen, the same shit happened with MMA, right? At some point, Section 4, if you violate Section 4, there's no Section 8. Remember those times?
Yeah,
Like,
good
that's where they
times.
try to take this shit, okay? So don't tell me that the worst of the worst, that's some shit that they came up with.
And that's going to be their first thing they do.
Right.
It's not even going to be the last thing they try. It'll be the first thing they do. They'll immediately say one or the other. They won't even mess around, and it'll be the standard. Like you said before, Pam will probably send out a letter saying this is how you should interpret it, and that's how the prosecutors will go.
Well, fortunately, again, we're going
Maybe not.
to have a different attorney general
Jamie,
in
listen,
place.
Listen,
And she can read that plain language just as well as we are right now.
I'm not
don't-
predicting.
She's not an
I don't see
asshole.
plain
And I agree with
language
you.
myself.
This is not a prediction. We're having my experience in the courts, how I would never have ever believed that something like this could ever happen. But as lawyers that saw the way this thing went down, you cannot take this leap into this basket of eggs and say, I'm going to live here and, it can't all be in the same basket. You got to be aware that, and even if it's the Court of Appeals, they set these tones. The worst thing, and it's terrible, I hate to even say it, O'Connell's concurring opinion.
Right.
That motherfucker sat down and said, you know what? This is going to be a confusing law. Let me take the pen and undo the confusion. Someone has to. I anoint myself, my Lord. And I will pen fucking 16 page of nonsense that little pieces are still referred to in the interpretation. One of which was it did not amend the public health code and serves as a limited protection. And that has been the mantra. So that shit that he fucking did.
And of course, then the attorney general came in
Reinforced
and supported that.
Listen, I agree.
He had language that he could have interpreted much differently, but it wasn't as clear as this.
I don't think it's clear, though. It's not. It doesn't actually say there.
Well, listen. This is if you're trying to
Three
fuck with
against
it, right?
one, Rex.
No.
It's
No.
Yeah, it
doesn't
I
say
would listen. This is what I'm
It
saying.
doesn't have to.
Well, then, there you go. You can't say that it clearly says it, but then say, well, it doesn't
It clearly
have to.
tells you.
It doesn't
It
clearly
tells
say
you
it.
that they don't conflict with each other.
That
and
doesn't mean
conflict.
that doesn't mean that you get to. It doesn't say it clearly stacks. Just not conflicting with
That's
each
right.
other doesn't.
You have an exemption for 12. And you also have an exemption for 72. It doesn't.
It's
it
not
says
clearly
that,
saying
that is exactly
this
correct.
act,
right. But it's whether
that's
the
where it
court
stops.
decides to apply those exemptions independently or combine them.
It's an argument over realism versus idealism. And idealistically, we agree. I think everybody at this table idealistically agrees what we want to have happen and what wasn't the intention of the drafters.
Right.
But realistically, which is the world that Jim and I are living in, it's not going down like that.
Actually, that's exactly what we all just agreed to a second ago. But what we're saying is that
But
nothing
you're saying
in there
it clearly
says.
says it, and it
Right,
doesn't.
I think it does. And,
Well, let's be clear
and
on
Michael
what we're
think
talking
it does too. We just realized that the courts are able to and willing to bastardize
It's
it.
kind of like the argument
If it
about
was
due
clearly-
process. Due process, like blatant unfairness, no notice, not a right to be heard. There's variations of that. If you felt like you're not able to have some of that, weren't proper. You cry due process violations. What I'm saying here is that it's almost like, and I say due process, it's like not as specifically articulate like the MMA, for example. We know that the intention of that, as it's listed in not paragraph 1, but 2 and 3, which is that marijuana is medicine, and that by passing this law to reduce the number of arrests, and this is for the greater health benefit of Michigan, something to that effect. Prong 2 and 3. That's like a preamble. Like we. 407, whatever. Some preamble to a declaration of a law. And the argument here is that this law clearly was intended to protect people from being arrested, and the people that are caregivers, and the people associated around them. Right? We know that. That's what it was. Yet we saw arrests go. How could this be? Right? And what we're talking about is it's the implementation in the spirit of the law, right? If they ignore, because there's never been an opinion that referred to those aspects of the MM. You know what I'm talking about? The prong 2 and 3, or the first, second paragraph and third paragraph. Michigan joins these other states in the well-being and health of their, citizens, and the NIDA study of 2008 that says that marijuana's treatment of pain, whatever.
Oh yeah.
So I'm saying those are the declarations. That's the beginning part of it, but those don't find themselves in opinions. Not until 2016 does the legislature, when they amended and fixed the usable marijuana brownie volume limitation, do they refer to it the first time and rely on it as a reason to go retroactively. Like, we were not able to fulfill our obligation as cited in paragraph 2, which to stop the number of arrests for sick people, right? So the point is that, why was that? Was it a legislative action? Was it a failure of the legislative act? You could say that. Was it a failure of the courts in some way? That the legislature needed to act to fix that, or the courts made bad decisions? Or was it the law enforcement community and the prosecutors that wanted to drive these issues? Remember, early on, the policy was, let's arrest first and figure out in court later. You know what I mean? And the way that was done is so antagonistic to the spirit of the law, right? To stop arresting. And I agree, so we're talking about policy in its implementation, which is a leadership issue. I think if we know this will not work unless we have strong leadership that understands that the people that got behind her, because she's the people's lawyer and she's going to interpret the people's law as a proposal, a ballot initiative, as it's intended, which is to err on the tie goes to the runner, right? Tie goes to the voter. Tie goes to the patient.
Tie goes to the Supreme Court. And no matter what we talk about, even though Dana Nessel may have a program, the Supreme Court will probably be looking at this. If Jamie's talking about it and it goes
and
to
we did not say, and if you have 72 plants on the Michigan Medical Marijuana Act, you then no longer have the rights to these 12 plants. So we did not prohibit doing that at all.
Listen, so I just wanted to be clear. We're talking about a policy as the law, they voted for legalization. What does that mean? Well, we got to look at the various blah, 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 blah. We got to get in here and dig out what this word means. Was there a comma, nuggatory, this shit, Okay, but if we step back and see what happened in 2008, well, they wanted medical marijuana not to be arrested and prosecuted. But, now what happened here? We want to legalize for adults. And there's a whole slew of things that people unequivocally approved of, okay? And so from a leadership standpoint, what is this law about? It's about implementing it in a way that is antagonistic to people getting arrested. If there's a close call, it should go to the people not getting arrested. If there's a call about forfeited, it should